Testing 1 2 3. Testing 1 2 3. Testing 1 2 3. Testing 1 2 3.
Good morning, everyone. Welcome. Our first case for argument this morning is Edward Snookus versus Matthew Taylor. Mr. Miller. Good morning.
To thank the court and the judges for the time that it's taken to review the briefs, to hear argument today, and my clients appreciate your time and efforts. I would like to begin by, I know the court knows all the facts, but just briefly to identify the players, the key players. There's Mr. Snookus, who is a gentleman who ends up dying as a result of this incident. There's Officer Taylor, who was a supervising officer, and his trainee, Trevor Kuntz. On the morning of the death of Mr. Snookus, September 13 of 2019, Officer Taylor, as a supervising training officer, told Officer Kuntz that he has to do the following every day. Every shift on every run, Officer Kuntz has to state the following: whoever I'm dealing with may try to kill me. I will not make a mistake so that my wife is a widow. I will not search until after subject is handcuffed and properly secured. Those statements describe exactly how Officer Kuntz treated Mr. Snookus when the officers arrived on the scene. There was no communication. There was no discussion. They simply, Officer Kuntz approached Mr. Snookus, grabbed his arm, and tried to put him, what would appear from the video, into handcuffs. Mr. Snookus was standing outside of a business that he thought he'd parked his truck at. And he'd gone inside and asked if his truck was there, and no one could help him. So he leaves the building and he walks out near the road. And the owner, the manager of the business, the collision center, calls 911 and says, hey, we got this guy. He was wandering around our lobby, thinks his car is here, it's not. But now he's standing outside by the road, and we're afraid he may be inebriated.
That's not exactly what he said in the call.
I'm not quoting, Your Honor, that's correct.
Yeah, let me quote. We have a gentleman who keeps coming into the back lot. He appears to be impaired, and he's kind of refusing to leave. He's kind of hanging outside. He's looking into the windows of the body shop, and he tried to walk into the main shop. We told him to leave, and he keeps coming back.
Yes, sir.
That's what the officers knew when they arrived at the scene and
Yes.
confronted your client. That's different than the officers knowing or thinking that he was there because he thought he parked his car in the parking lot and he was innocently looking for his car.
Thank you, Your Honor. I apologize for misstating.
But I think that's important to the extent that it goes to your claim of excessive force and particularly qualified immunity. You know, how do you get around the qualified immunity argument here? What's your best case that says in circumstances like this, the officer should not have approached Mr. Snookus with the intention to handcuff him?
We've cited the Gupta case and discussed it in our brief and believe that to be
The best one?
the best one for us. Yes, Your Honor. Understanding there's not a lot of case law on this specific set of facts. But back to, I'm sorry.
Well, let me, since you're talking about the facts, let me ask you about the record. What record evidence do we have about Officer Taylor's strikes to Mr. Snookus's head? Now, both parties cite Taylor's deposition, the use of force report. Both parties are saying 4 to 6 hits. I'm looking at the deposition, the use of force report. That number's not in there. So I have 2 questions. Where do we find the number? It's not in what either party has cited. And what do we have in the record about the hits? Were they quick in succession? Were they delayed? Is the number of hits disputed?
I don't believe it is. I believed that it was in the use of force report submitted by Officer Taylor, as well as the investigative report that was designated in part of the record. I can't quote the court to that particular page or citation, and I do apologize for that. But it is obviously an important question. It has been undisputed in the briefing that it was 6 strikes to the head with a closed fist. That comes a little bit later. I'd like to go back in the sequence of events.
And what about my question about how quickly those strikes happened? Were they boom, 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 or was there a delay between the strikes? Because if you recall, well, I know you recall, we have black video. The video is blacked out for that portion. All we have is audio.
Right. No, well, there is audio on both cameras, and there's no video on one camera. The other camera is not lit up until the third officer, Hackworth, shows up and shines his light onto the two other officers. So if you look at Officer Hackworth's vehicle deck cam and his body cam, you will be able to see the last attempts to secure Mr. Snookus.
So you're telling me on that video you can see hits?
I believe that is correct, yes, Your Honor. And there's also the witness who saw the officer, Christy McGowan, who saw the officer, according to the police report, investigative report, excuse me, on top of Mr. Snookus, and I believe attempting to strike him. But to get to your point, there's been no dispute that he struck him. It's been justified as being reasonable because he was grabbing for his groin, he was grabbing for his gun or his taser, even though we believe the evidence shows, as we pointed out in the brief, that that couldn't have happened because of the way that the officers were situated on top of him. So the beginning, to go back to the beginning, I think is important in a couple of respects. Your Honor points out that exactly what was said is important to know what the officers knew at the time. The officers weren't aware of all of the information that unknown, bald, white man had supposedly done in the vicinity earlier in the day. None of that was known to the officers, and there's simply no evidence that it was. What was known is that this trainee, Officer Kuntz, was having difficulty with his training, his field training. He was assigned to Officer Taylor, and Officer Taylor, from the moment they began, the day of this incident, told him to be more aggressive, told him that anyone, not someone who has an arrest warrant, not someone who's been accused of a violent or severe crime, that anyone he may come into contact with will try to kill him. So he was told through that message and through his other training that he should be aggressive with everyone and assume that everyone would try to kill him. We believe that set the dominoes in effect, that that's where this begins, and it escalates because of that, not because of anything Mr. Snookus did, or at the very least that the facts are disputed about that. So one example of that would be, did Mr. Snookus do a roundhouse punch at Officer Kuntz? The Officer Taylor says he did. Officer Kuntz says he did. I've looked at the video. There's two different angles, and I don't see, our expert didn't see, Mr. Snookus swinging at either of the officers. It appears that he swings his body away from the officer, and they both fall to the ground.
The defendants say Snookus was resisting and struggling the entire time they were attempting to handcuff him, okay?
Yes, that's correct.
Below in the district court, did you dispute this fact? And if so,
Yes.
what's the citation? Where?
In the briefing or in the record? It would be in our dispute is the video footage itself. He does not, well, let me back up. What they don't do when they arrive on the scene, what the officers do not do, is say why they're there.
No, I'm asking you where below. So you're
in
saying
in the body cam.
no. Where below? You're saying in what briefing did you dispute the fact that he was?
In our original brief in response to the motion for summary judgment, Your Honor.
And what about in the facts that you submitted to the district court for summary judgment?
That's in the same document, yes.
Mm-hmm. And maybe when you come back, you can tell me which paragraph.
I'll try to find that.
Thank you.
Okay. Just have a couple more other minutes of my initial time. Does anyone have another question? Okay. I'll reserve the remainder of my time.
That's fine. Thank you. Mr. Loberman.
Good morning, Your Honors, and may it please the Court. I just wanted to pick up briefly on that last question about any dispute regarding whether Officer Koontz was punched. And I don't have the page in Mr. Miller's briefs handy, Your Honor, but I can say that the District Court did address this issue. The only suggestion of a dispute that Mr. Miller offered in those briefs was that the video does not show the punch happening. But as the District Court noted, that the evidence for the punch happening didn't come from citations to the video, it came from the officer's depositions. And there is no evidence to rebut that in the record that I've been able to locate or that Mr. Miller has referred to. So I don't believe there is a genuine dispute as to whether Officer Koontz was punched in the face by Mr. Snookus. And generally, along those same lines, to address some of the other questions that came up before, this description of, there was no communication with Mr. Snookus when officers arrived on scene. Well, that's not true, and that is on video. Officer Koontz said, "Put your hands over your head. Put your hands over your head." And Mr. Snookus seems to indicate that he understands what he's being asked. He said, "Well, hey, what's going on? Why?" But he does not comply. And what is shown in the video is when Officer Koontz moves to put Mr. Snookus' arm behind him, he starts turning away and swinging toward, his arms are now in motion. There's not a lot of clarity as to where, if at any point, his fists may have connected, but Officer Koontz testified to that point.
Is there clarity in the record about the number of hits, number of times Taylor hit Snookus?
There is, there's not Officer Taylor recalled it, I believe, in his use of force report somewhere between 3 and 6, and in his deposition, I believe he gave a different number. But I don't think the parties dispute that there was, in that range of numbers, we've consistently used 4 and 6 in the briefing. I
ask because I don't see, every time the parties cite in the briefs these page numbers, that information is not on any of the page numbers either party cites. But let me ask you this, even if it wasn't excessive force, even if the first couple of strikes weren't excessive force, why was it not excessive for Taylor to hit Snookus 4, 5, 6 times? Okay,
so I'll begin my answer to that question. I know when Mr. Miller was discussing this, Your Honor's question was about, the timing. We don't have any evidence on the timing as far as whether they were in quick succession or if there is any type of pause in between to assess whether Mr. Snookus was beginning to comply, or we just don't have that in the record. There's no, from best we can tell from the deposition testimony and the video, and which I understand is dark. Visually, there's no video evidence on this point by the time this part of the incident is occurring. But there are a number of sounds that Mr. Snookus makes throughout, and we don't know the temporality in the video where exactly the strikes are administered. But Officer Taylor's testimony, again, similarly to Officer Koontz's testimony, unrebutted, is that he issued those strikes until he was able to obtain compliance. And given the situation in particular, whether it was intending to cause harm by grabbing onto his genitals, a sensitive area, or whether it was attempting to reach for a weapon, he had a very compelling reason to ensure that he was gaining the compliance he needed to make the scene safe. And that is, when the video comes back to being visible, Mr. Snookus has seemed to sort of start slipping into unconsciousness. He becomes more pliant, and they're able to handcuff him. And that's when Officer Hackworth arrives on the scene. And as soon as they realize that he's unconscious is when Officer Hackworth calls for AMR, which is Evansville's ambulance service. They check his pulse, check his breathing. Initially, both of those things are still present. They administer sternum rubs to try and jolt him back into consciousness.
Let me ask you one more thing on this. When, in your view, if a suspect like Snookus is actively resisting, when, in your view, does the force become a jury question? After 6 punches, maybe after 30? Do we need 50 punches? At what point, even if a suspect is actively resisting?
I would say, Your Honor, I think whether the number of punches becomes a jury question is going to depend on whether there's a dispute of fact as to whether those punches were necessary. Here we don't have that. It would be my submission. We don't have, again, we don't know the timing. I think both of us would agree
So if we
on
have
that.
the same facts here, and counsel did not dispute below, as is your position about the active resistance, there still would be no question if the officer had hit Snookus 100 times. There's no dispute, question over about excessive force.
I would say, Your Honor, given that the clear testimony is that when that use of force attempts were not occurring on Mr. Snookus when he was not actively resisting, that is something I wanted to underscore in general. There is no suggestion here in the evidence that Mr. Snookus was harmed while pacified or detained. So I would say if the situation is that if there's an actively resisting suspect, until there's a genuine dispute about whether they were rendered secured by however many strikes, then there wouldn't be a jury question to reach it. Probably got a little mixed up in there, but let me try it again. There's no dispute. If there's no dispute that the number of strikes issued were used to bring an actively resisting suspect into compliance, which I submit is the case here, then I don't see where that becomes a jury question. If there was some other piece of evidence, video that suggested that there was a lull in between strikes that the officer could have picked up on, that would be a different question. That could be something a jury could be asked to resolve. I hope that answered Your Honor's question. There was some discussion on qualified immunity I wanted to address as well. The Gupta case has, near as I can tell, no bearing on this one. And as the court knows well, when we look for authority that clearly establishes the rights that the plaintiff is contending are violated, that case should be on all fours to the situation that's presented in this case, and Gupta is simply not. And the generality of a suspect who is not a threat should not be harmed doesn't really apply in this case. This is a case where, as has been discussed already, there was active resistance. There is no factual dispute on that question, and officers' uses of force were only to address that active resistance. There's simply no reason they should have been expected to know that efforts to detain Mr. Snookus and handcuff him in the initial instance when he refused to comply with their instructions. They had probable cause to stop him. They, as Judge Kirsch quoted from the dispatch calls, there was ample reason to suspect criminal activity was afoot when officers arrived and confronted Mr. Snookus. So that initial handcuffing decision, the taser usages, where at this point, and it is clear in the video at that point, Mr. Snookus and Officer Kunzer actively have fallen to the ground. They're scrapping. Mr. Snookus is attempting to flee. Officer Taylor tried to use his taser. It didn't work so well. He rolled around and pulled the barbs out. And he tried to use his taser again. It didn't work for that reason, and then he flees. That, whether it's the strikes at the end, the taser in the middle, or the handcuffs at the beginning, or the attempted handcuffs at the beginning, at the very least, there would be qualified immunity on all of those points. But I think the district court did correctly identify that each of these uses would be reasonable under our Graham factors, under the comparison to the Dockery v. Blackburn case is the most compelling legal citation throughout this briefing, whether it's below or here before this court. In that case, of course, this court found that where a suspect was actively resisting and attempting to remove taser barbs from their body and was attempting to stand despite being ordered to remain on the ground, which is virtually identical to what happened in the situation with Mr. Snookus, that was a reasonable use of force. And I understand that there are other uses of force that aren't necessarily contemplated within the scope of the Dockery case, but along those same guiding principles, those uses of force are reasonable as well. Really, I think appellant's argument throughout this whole thing asks the court to ignore portions of the record that are clearly established in the video. And it reflects in statements like that there was no communication before Officer Kuntz attempted to arrest Mr. Snookus. It reflects in the, well, we didn't see the punch on the video, therefore there's a dispute. That's not in the record. So, and when you do look at the record, there can be only one conclusion: these officers reacted to a situation that they were put into by Mr. Snookus' active resistance. And as much as I'm sure they would wish it weren't so, to be put in that situation, that is nevertheless what happened to them. And
if the video doesn't show the punches, and as you say, it's not apparent whether there was a lull between the punches, would that not be drawing inferences at summary judgment in favor of defendants rather than Mr. Snookus, that the officers did not have a chance between hit 1 and 2 or 2 or 3 or 3 or 4 or 5 or 6 to evaluate whether Mr. Snookus was complying before using more force? Talk to me about which way the inferences are being drawn there.
Yes, Your Honor. I would say in the city's initial burden on summary judgment, they put up undisputed evidence that these strikes occurred and that they were necessary to gain compliance over Mr. Snookus, who at that point was still actively resisting on a scuffle on the floor, on the ground with the officers. If there were to be an inference that could be drawn in appellant's favor, they would need to show their burden, not just simply say, well, we don't see this, we don't know. They need to make their burden to show evidence as to why there should be an inference drawn in their favor, at the very least, if not directly conflicting with the city's position. That we don't have that. We're asking for an inference that there be an inference, is what this feels like coming from that argument. If there was to be, and along those lines to the question of whether there should be a jury question on the number of strikes that were delivered to Mr. Snookus, first there would need to be some kind of dispute as to whether that was material, in the sense that if there was any way to dispute that the strikes administered were necessary. We don't have any reason to dispute Officer Taylor's testimony that Mr. Snookus did not stop until after he delivered all of the strikes that he delivered. So without something to that effect, there would be no need to parse between the punches. It simply is, there's no material distinction that comes from that, given that Officer Taylor's testimony at that point is completely uncontradicted. So I think I managed to address all the points I came prepared to make. If there are any other further questions from the court, then thank you for your time.
Thank you. Mr. Miller.
Your Honor, I don't have my brief from the district court with me today, and I do apologize for that, so I'm unable to answer your question. There's one point I want to ask that the court consider, and that is that during the encounter on the ground with Mr. Snukas. And if you listen to both of the tapes and watch the deck cam from Officer Hackworth's vehicle, what you're going to hear silence. There are periods of time where you don't hear anything. And at some point after those periods of time, you hear loud shouting, "Stop resisting, stop resisting." If you look at the timestamp at that point and compare it to the outline of the timestamp in our brief, you'll see that that's already at a point that Mr. Snukas is indicating signs of distress, where he's already agonally breathing, where he's already saying, "I cannot breathe." Those things have already happened when Officer Taylor, we believe it was, said, "Stop resisting, stop resisting, stop resisting." Secondly, we pointed out in our briefing in this court that the Officer Kuntz's use of force report describes his force exercised against Mr. Snukas in a way that would have made it impossible for Mr. Snukas to have been reaching around and grabbing Officer Taylor at all. Testimony undisputed is that Officer Kuntz was holding his legs, Officer Taylor was at the upper body, Officer Kuntz was holding Mr. Snukas's left arm, and Officer Taylor was attempting to retrieve the right arm from underneath his body. Well, if Officer Kuntz has the left arm and Officer Taylor's trying to get the right arm from underneath his body, which arm is grabbing his crotch? Which arm is grabbing his gun? How can it be that what he says is true? That is exactly the type of inference from the actual evidence that a jury should decide whether that testimony is reasonable. Why? The witness that we could have presented evidence from is dead. He can't speak. And I don't say that this court would intend this, but if death results in the elimination of the only witness who could tell the other side of the story, which is this case, then there is a perverse incentive to make sure that the person doesn't survive, because then there's no witness. I'm not saying that happens, but I'm saying in the psyche, in the culture, it would be better for the police if the witness does not survive. If the jury gets to decide whether or not it was reasonable force, whether or not there was active resistance, whether or not there was a reason to detain or arrest Mr. Kuntz or Mr. Snukas by Officer Kuntz at the very beginning, that's a different story. All of those steps are key to this, and we've outlined them in our brief, and I won't repeat them. But all of those steps are key to understanding what happened and when, and who is able to testify and who is not. And Mr. Snukas is not. He was silenced. Now, there is evidence in the record. There was not a request for summary judgment on cause of death, but the evidence was submitted. And that evidence shows both the expert report of Mr. Pusins as well as the report of Dr. Wecht, Cyril Wecht, that the officers did, in fact, strike his head, and that did contribute to his death. Excuse me, sorry. We point out that, this information about striking Mr. Snukas in the head was not reported by the police officers on site during the autopsy report, and it suggests that may be evidence of an attempt to cover up in the autopsy determination of the significance of the strikes to the head. That's as far as we can go with it, and it may or may not be something the court wishes to consider. Those are all of my remarks, if there are any questions. Thank you for your time.
Thanks to all counsel. The case will be taken under advisement, and we'll move to our second case this morning, A.B. versus Mike Braun. Ms. Lowry.
Good morning, Your Honors. May it please the Court. My name is Marcia Lowry, and I am arguing today, excuse me, on behalf of appellants. This lawsuit is about the comedy and the balance between the federal court's obligation, unfailing obligation to take on that for which it has jurisdiction, and the respect and deference to the state court for its legitimate interest in avoiding interference in the management of its affairs. This is a case that was dismissed below on a motion to dismiss, and the district court decided, based largely on Ashley W., which was a case prior to this, and supported that decision by relying on Moore v. Sims, a Supreme Court decision, and two other cases in this circuit, Brunken and Milchstein. In Ashley W., the court said, we know that Younger applies to state-initiated child welfare litigation. Basically what this case is about is whether children in the foster care system in Indiana have a right to bring a federal court action, notwithstanding the fact that they have ongoing judicial proceedings to review what's happening to them while they're in the state foster care system. Moore v. Sims was a case about parents who sought to enjoin a state court process about the removal of their children. They did seek to get the process enjoined, and it went to the Supreme Court. The Supreme Court said abstention allows that the federal court should not have acted. There are basically no cases in which children have been denied access to the federal courts for their ongoing proceedings. And what our position is, and we think it's correct, is that the decisions in both Sprint and New Orleans Public Service versus New Orleans, often referred to as NOPSI, substantially limit the doctrine of jurisdiction.
How do you address our opinion in Woodard?
I'm sorry, Your Honor?
How do you address our opinion in Woodard?
In Woodard.
Yeah, that's the recent case where we talked about, let me see if I can find a site for you, but it's a recent case where we talked about federalism and comedy and abstained in a similar situation, even when we said, look, Younger was not a perfect fit. We acknowledged it in Woodard that Younger was not a perfect fit, but yet we abstained.
Right. Your Honor, I think that the abstention doctrine is extremely limited, and I think that we have to go back to Sprint to see exactly how limited it is.
Yeah, I understand that, but does that mean that Woodard is wrong and that we have to overturn it? I mean, I guess what are you asking us to do?
I'm asking you to do two things. I'm asking you to limit Ashley W. to its facts.
Okay, so let's say we do that.
All right, and then, Your Honor, I'm asking you to remand this case back to the district.
But what do we do with Woodard?
Your Honor, I'm not familiar with that case.
Okay.
It's also,
Yeah.
the full case name is J.B. versus Woodard. I
Yeah.
think it's ubiquitous in this case, and so I'm sure you're familiar with it. It may not be familiar to you by the name Woodard. It's J.B. versus Woodard. It features prominently here because it is also arising in the context of child neglect and abuse cases.
All right, but the plaintiff, who is the plaintiff in that case? I mean, that's what really makes the difference, because Sprint says that abstention is limited to criminal proceedings, civil proceedings quasi-criminal in nature to sanction the federal plaintiffs for some wrongful act, and civil proceedings in furtherance of the court's ability. And so if Woodard, with which I say I'm not familiar, did not in fact fall into one of those categories, then the court should not have abstained. But,
So JB versus Woodard also needs to be overruled.
well, Your Honor, I'm sure that somehow was a reasonable exercise of the court's decision. But what we're here about today is basically the decisions that have already been made in this case, which is having to do with Ashley W., which we think can be limited to its facts. This case does not in any way seek to interfere with any juvenile court decisions that it has made. So this is a case against the public agency that is responsible for the environment in which children find themselves. And plaintiffs are dependent upon, plaintiffs in this case who are foster children, are dependent on the public agency to create the environment in which they live. The ongoing proceedings, which are about every 6 months, have to do with basically what the child's circumstance is, what the family court, what the juvenile court does to provide the child's medical care, the child's treatment.
Can I ask you another question?
Sure.
What about Courthouse News Services versus Brown? Can
Right,
you address that case? I mean, in that case, let me just quote, we talk about abstention doctrines and we say they were not a perfect fit, meaning younger abstention was not a perfect fit.
Right.
And we ultimately base our decision on the more general principles of federalism that underlie all of the abstention doctrines.
Right.
Is Courthouse News Services wrong?
No, it's not wrong, Your Honor, because in that case, the issue was whether or not some certain information would be made available more quickly to the people who sought it. Once again, what we're talking about, not exercising abstention in cases that do not fit within the limited descriptions in Sprint. Sprint narrowed the abstention doctrine. Moore v. Sims.
Sprint, yeah, I get that. Sprint dealt with younger abstention, though, and we have cases that talk about we still will abstain even if younger abstention is not a perfect fit. And I understand your argument regarding Ashley W. I understand that. I understand your argument regarding Smith, or regarding Sprint. But what do we do with Courthouse News Services? What do we do with Woodard? What do we do with SKS and Associates? And I recognize that some other circuits don't agree with the way we've handled abstention in the past. But do we need to change our law on abstention to rule in your favor?
No, Your Honor. I think for the most part, with the exception of a couple of these cases where I think the court has gone a little bit further than it needs to, but it can be limited to its facts, as we say with Ashley W. But
it's hard for me to imagine a fact scenario that is more focused on state interests than this case. So I hear what you're saying, that we can limit it on its facts, but boy, oh boy, I mean, you are digging right down into what is uniquely within the province of the states. We say that over and over and over again. When you're talking about, you're basically talking about child custody issues in the foster care system. That is uniquely within the state court system. I mean, one of the reliefs you seek is asking a United States federal court to require the state of Indiana to establish an entirely new state department. And I can't think of something that would infringe more on purposes of federalism than that. I can't think of anything.
Well, Your Honor, clearly there's a state interest here, but there's also a federal interest in what happens to children when they're in foster care. The children who come into foster care are children who are paid for by substantial amounts of federal money, and there is federal law that governs what's supposed to happen to them.
And state courts are equally equipped to adjudicate federal claims, and
Your
that's the
Honor?
whole point of this doctrine of abstention, whether it falls in the basket of younger or some other form of abstention, as we explained in JB versus Woodard, SKS, Courthouse News Services versus Brown, Driftless. We've got countless decisions about this explaining that this is not a matter of checking boxes or fitting within baskets. It's all about federalism and comity
Yes.
to the state courts. And so when the state courts can vindicate the federal interest, and it's our core state policy area and legal area, as this one is in the domain of domestic relations, child abuse, and neglect, then abstention is warranted.
Right. Your Honor, abstention is a doctrine that is about withholding jurisdiction that exists. And when we deal with some of the softer areas, there have been different abstention doctrines. There's Burford doctrines, there's Colorado River. But when we get to Moore v. Sims, what we're talking about is, number one, the separation of parent and child. Abstention applies there. And then what we're also talking about is the ongoing proceedings that are carried out by the state court. And for those ongoing proceedings, the children are in the custody of the Department of Social Services. And their conduct depends on what happens to them, depends on what the Department of Social Services, not the courts, what the Department of Social Services makes available to the courts. What does the court get to choose from? What if a child needs a different kind of placement? Can the court place the child any place? No. They can only place the child in what's available. And that is an area where abstention should not be exercised. That is an area that courts elsewhere have upheld the jurisdiction for. And in fact, a recent case that came out, I think about a week and a half after Ashley W., Jonathan R. in the Fourth Circuit found that for those children who are in the custody of the state, basically this is about the conditions of confinement. And this court has been very respectful of the conditions of confinement. And there are federal claims that can be brought in federal court because of the conditions of confinement. And if the child welfare system operates the way we assert it does operate in Indiana, and that's in our complaint, then the federal court has a right to intervene. And that is different, and that is an area where abstention should not apply. And elsewhere in other circuits, where abstention does not, in fact, apply. And that is what we're talking about here when we talk about whether there should be abstention. Yes, it's an area of state concern, of course it is, but it is also an area of federal concern. The constitutional rights and federal statutes should not be violated if a system operates in such a way that the children who are in it have such limited options that, and the courts can only provide the children with the options that are available to it, because the courts don't create foster parents. The courts don't, in fact, decide how many cases a worker can have. The courts do not decide whether a child is being placed in a foster home where the child gets beaten up. And as you can see from our complaint, of the situations of the plaintiffs that we represent has been very, very troubling in terms of what's happened to them. Basically, this is like a prison system where the prisoners do not have to wait until they try suicide, as some of the children we represent have, before the conditions that they can't get medical treatment are addressed. They have a right, a federal right, to have their conditions of confinement addressed. So here we're talking about the conditions of confinement for the children in the system whose parent-child relationship issue has been resolved. That's when they come into the system, and when the state court says, okay, you are a CHINS, your parent committed acts of abuse or whatever it was, and so the parent-child relationship's a protected relationship, and the child becomes a CHINS, but then what happens to the child? This is about conditions of confinement in the foster care system, and what we're asserting in this case is that the conditions of confinement are very real, and the children have a right to challenge those conditions of confinement in a federal lawsuit. That's what this case is about. And so when you get to something like Courthouse News, where some of the issues get a little squishy, it's not a legal term, where things get a little bit softer, there are other rules. But here, we are not seeking to interfere with any judgments that the state courts make. We are not seeking to interfere with the operations of the state court. I think my time is up.
It is.
Okay. Thank you, Your Honor. I reserve 3 minutes for rebuttal.
Actually, you've already used all your time, but I will give you
Okay.
some additional time.
Thank you very much.
After Mr. Barta has his chance.
May it please the court. One of the state's most vital functions is protecting abused and neglected children from harm, and every day the department seeks to do just that through CHIN's proceedings overseen by state courts. Even plaintiffs admit that these proceedings are the type of quasi-criminal proceeding to which Younger applies, at least from their initiation through the dispositional decree. And at no point do the proceedings transmute into something else. Every semi-annual review after the dispositional decree is there to give effect to the objectives of the dispositional decree. From start to finish, these proceedings are about protecting children in harm's way. So the critical question for both Younger and standing purposes is whether a federal judge could lawfully grant any relief to the 2 children with ongoing cases that a state court judge could not. And the answer is no. State courts hear federal claims and can use their authority to address any concrete problem that a child actually faces, whether that's the need for different services or a different placement. And federal courts, limited by Article 3, aren't any better equipped to address plaintiffs' more abstract concerns about how making the system better as a whole.
Let me ask you about a case that's come up through our court, through Illinois, not Indiana. And one of the amicus briefs raises this. They give examples where advocates have sought reform of state child welfare agencies in federal court. And one of the examples, of course, is BH versus McDonald, which is an Illinois case that's currently still in federal court in this very building and has been up to our court on appeal. And that case, if I'm following your argument, that case should not even it should not even exist in federal court because abstention should have barred it from existing. So I'm asking why is the federal court equipped in BH v. McDonald, which is challenging the Illinois Department of Children and Family Services and the provision of care and how care is provided to children in the foster care system there. Why was the federal court there equipped to respond to the systemic issues about food, shelter, clothing, and health care in that case, but not when it comes to issues raised here about staffing and medical care? What's the difference as you see it?
So, setting aside that not every state agency chooses to contest cases on Younger, I think one of the critical things is particulars matter a lot when we're dealing with Younger, because of course one of the considerations under Younger is, do you actually have an adequate forum in state court? And so if a state limits the authority of their judges overseeing the proceedings, or doesn't allow certain claims to be raised, that can mean that a case that would otherwise be subject to Younger goes into federal court.
Well, let me ask you a broader question, though, because one of the things I hear Judge Kirsch asking and Chief Judge Sykes asking is there are broader issues of comity and federalism that one ought to consider here. Apply that to the BH v. McDonald example. Why wouldn't of those broader issues of federalism and comity have not made it so our circuit did not say that case should not be in federal court, and when it came to the Seventh Circuit, we didn't dismiss it?
So with the caveat, I don't remember offhand whether this court addressed Younger specifically in that case, but
what I'm saying is you have to take it out of Younger.
Right.
The panel is asking non-Younger abstention questions.
Well, I think even if you set Younger aside, certainly the federalism and comity very much limit what types of relief a federal court can lawfully impose. And that's exactly the point the Supreme Court made in Nopsey when describing how Younger is really rooted in the idea that when it comes to equitable remedies, there are principles outside just whether courts have jurisdiction that limit what relief can be granted. And so I think when we're dealing with these types of cases and there's requests to essentially create a court-administered substitute child welfare agency, that is not something that courts could lawfully grant as relief, whether you label it under Younger or Article 3.
But I'm still curious about your answer, because that seems to be precisely what's happening in BHV McDonald. There's a consent decree in operation right now for years about reforms to the Illinois Child Welfare Agency.
And I
How
think,
could that be?
I think that, Your Honor, just goes to show that some states just simply find it more expedient to enter into consent decrees rather than engage with the principles of federalism and the constraints imposed by Article 3 that inform these types of cases.
There's often an incentive to do so because it pries loose money from the state legislature if a federal court is breathing down your neck.
That can certainly be the case, Your Honor. And I think that is why that, in some sense, there's really no distinction between this case and Ashley W. The only remedy that it seems like would actually make the system better would be more money, which is something the plaintiffs are requesting. And just in Ashley W., we have children involved in ongoing CHINS cases. We, even after the dispositional decree, we have requests for systematic relief, and we have even some of identical requests for relief, such as relief related to numbers of caseloads.
So can you also help me to understand the CHINS proceedings a little better?
Sure.
Can a CHINS court order DCS to make some of the changes, the system-wide changes that plaintiffs are asking for here? What are the CHINS court's constraints in that area, if at all?
CHINS courts can enter relief. I think the phrase is control the conduct of any person in relation to the child in front of them. So that would certainly involve telling the department, you need to find a particular type of specialized therapist, which they have done.
I was asking about their systemic request for release. It's clear, you all have made it very clear and helped us to understand they can order relief for the child in front of them, the child's particular case. I'm asking about the larger systemic requests plaintiffs have.
Well, I think oftentimes those can have larger systemic impacts. For example, if the request is to provide a particular specialized type of therapist that the department doesn't have under contract, then the department is going to have to go out, find that therapist, put them under contract so they can provide that service. And that's exactly the situation that a federal judge would be in, because at this point we don't have a certified class action. All we have are individual cases, and even certification of a class doesn't create greater substantive rights than an individual plaintiff would otherwise have. It's just a procedural device to collect it. And so if, in that respect, I don't think federal judges are any better equipped to address the difficult problems that accompany children in these tough situations than state courts that live with this day in and day out. And so I think that sort of also feeds into not just the Younger issues, but also the standing. Because and I think if we look at pages 19 and 20 of the plaintiff's reply, the harms there are really abstract risks, not concrete harms, precisely because state courts can deal with those. And so, whether we look at this under Younger or standing, I think there's just a jurisdictional problem.
I was wondering if you did want to address Woodward. It doesn't appear that either party cited JB versus Woodward in their brief. So you did not either. Did you want to address it now?
Happy to talk about it, Your Honor. So I think even apart from sort of Younger, there is a larger domestic relations exception to federal jurisdiction that I think certainly covers Woodward and just reflects the broader principle that I think the Supreme Court has recognized, is that when it comes to domestic relations, whether we're talking about sort of divorce proceedings or child removal proceedings, these are simply not the types of disputes in which federal courts should be handling. If there are any further questions, I'd be happy to address them. Otherwise, I'd be happy to cede the remaining time to the court.
Thank you. Ms. Lowry, you used all your time, but I'll give you a couple of minutes in rebuttal if you have anything further to say.
I'll be very brief, Your Honor, and thank you for that. Basically, the principle is that if there's not a specific exception that the situation falls into, the court must exercise jurisdiction. And there is no exception that these ongoing proceedings fall into. On a practical level, however, and I also wanted to address Your Honor's question, there is no way that these children are going to get any relief in the individual proceedings. Maybe an individual child will get a better placement, but there was an amicus brief that was submitted in support of our position, which says you cannot get this relief in the state courts, in which practitioners in Indiana submitted the brief. But it is clear that when a child, that if there's no system that is adequate for the child, the system is over here. We're not seeking to interfere with the proceedings of the state juvenile court proceedings. But if there's no system that provides what the child's needs, the state court, all committed individuals, I'm sure, cannot give it to the child. There needs to be a better system, and the stories that we describe of our plaintiffs in this complaint are very dire. The only way they are going to get remedied and are getting remedies that will be useful to them is if the federal court can take jurisdiction of this case. And as I say, if there is no specific abstentions and exception category, the federal courts are supposed to take jurisdiction unless, and there's no unless here for the ongoing proceedings, and other systems have not abstained, and that's why some of these systems are better than Indiana's. I appreciate the court's indulgence in allowing me to talk further. Thank you very much, Your Honor.
Thank you very much. Our thanks to all counsel. The case is taken under advisement. And we'll move to our third case this morning. Ronald Gaines versus Thomas Dart. Mr. Casper.
Good morning, Your Honors. May it please the Court. I'm here arguing on behalf of Plaintiff Appellant Ronald Gaines. There's two primary issues in the brief, and I'm going to focus on the cat's paw issue to start out. The plaintiff submits that the district court erred in granting summary judgment because plaintiff presented enough evidence for a jury to determine whether or not Adriana Morales, the decision maker in the termination, was influenced by defendant Carmen Ruffin, who harbored the anti-age animus toward Gaines. We submit that as a matter of the Schandl-Myers-Bartels versus Chicago Park District case and the Vega versus Chicago Park District case, that a jury should have been allowed to decide the cat's paw issue. Again, that is whether Morales was the cat's paw of Ruffin in this case. To start out, we know from Morales' deposition that the sole thing she reviewed was the OPR file in this case in coming to her determination to terminate Gaines. So to understand the lack of independence between Morales and the ageist Ruffin here, we need to analyze what's in that OPR file specifically.
And the OPR file is what?
That is the Office of Professional Review Internal Affairs investigation file that was compiled against Gaines, that decision maker Morales reviewed and used to justify the termination.
And Ruffin wasn't the investigator.
Ruffin was not the investigator. The investigator was a man named Ayman Zabadni, okay? And let's walk through the different parts of this OPR file that Zabadni compiled and discuss the connection to Ruffin. First of all, there are some interviews of individuals that Zabadni interviewed in his OPR file. However, when we review these interviews, most of them have nothing whatsoever to do with Gaines or Gaines's alleged misconduct. Let me start with the easy ones. Zabodny interviewed Officer Messina. All Messina talked about was his perceptions of Gaines's workplace injury, which had nothing to do with anything. So Officer Messina's interview is irrelevant, but it's in the OPR file. Zabodny interviewed Officer Foker. Again, Foker only talked about Gaines's workplace injury, which had nothing to do with any of the alleged misconduct. It's in there,
Well, I thought
and it's
the
irrelevant.
whole issue of the workplace injury and medical reports and so forth had something to do with his explanation for why he was AWOL.
But
And so it was relevant.
those
It's
specific-
not true that it had nothing to do with the misconduct. The misconduct was that he was AWOL.
the alleged misconduct was that he was AWOL during his shift, but those two particular officers that were interviewed, they didn't give any relevant information beyond just information about their perceptions of whether or not he had a workplace injury. So it wasn't connected at all to the AWOL allegation, is what I'm saying.
Well, the investigator was not on a frolic and detour in doing those interviews, was trying to get to the bottom of what I understood to be his defense, that he was getting medical records when he was AWOL so that he could justify his medical injury,
Well,
that was his narrative?
it was a frolic and detour. Those particular officers had no relevant information about whether or not Gaines was AWOL or not on August 13, 2024. Those were a frolic and detour. They were irrelevant make-weight interviews that yielded no relevant evidence.
Well, it had to do with his excuse.
But
And so,
neither one of them had any information about whether Gaines was AWOL on August 13th. And that's why they were relevant.
Can you connect the dots, though? Are you trying to tell us that Ruffin dictated these irrelevant interviews? What's the connection here? Skip to the point that you're making about these interviews.
Well, what I'm trying to say is that Morales reviewed this OPR file, and it was a bunch of either irrelevant make-weight that had no bearing on the AWOL allegation, such as these interviews, or it was information suggested by Ruffin. And let me talk about that. There was, for example, the daily activity reports that Zabodny collected. He gets those from Ruffin. There was the allegation that Gaines was AWOL. He gets that allegation, which Justice Sykes, you were talking about. He gets that to start from Ruffin. That's Ruffin who starts the ball rolling on that allegation. There's the GPS records. He doesn't get those from Ruffin, but she suggests that he get the GPS records.
Stop there.
Sorry.
Isn't that the end of your cat's paw theory? Doesn't that defeat it right there? I mean, let's say you're right on the OPR investigation and the interviews. How do you deal with the GPS records, the surveillance logs, the daily activity reports? I mean, remember, you have to prove that Ruffin's, or establish that Ruffin's interview was not independent.
Yes.
How do you deal with that stuff?
Because, Your Honor, between Zabodny's deposition and reviewing the GPS records themselves, they don't establish that he was AWOL at all.
Okay, so that's fine. Ruffin's wrong. Ruffin's wrong. Ruffin's wrong. How does that establish a cat's paw theory? If Ruffin can review information and come to the wrong conclusion, that does not amount to a constitutional violation. Or does it?
Because, Your Honor, Morales, who was the decision maker, influenced by Ruffin, as we say, Morales said that she was swayed that the OPR file showed that Gaines visited his boathouse.
So what?
Because it's false. That is
So
false.
what? There's this other evidence that she looked at as well in making the decision. Doesn't that defeat your cat's paw theory?
It does
And maybe
not.
I'm wrong. Okay, go
It does
explain
not.
why.
Because I break down every piece of evidence in the brief here that's in that OPR file. None of it establishes AWOL. All of it, almost all of it, comes or was suggested by Ruffin. All of it. So yes, it's true Zabodny collected this information. But like the GPS records, there's not even a GPS record in the record for August 13th. That's the day he's allegedly AWOL. There's no GPS record for August 13th. There's the daily activity reports in the OPR file. There's no daily activity report for August 13th. And this is the date, mind you, that Ruffin says Gaines was AWOL, August 13th. if that's such a big deal, Your Honors, why is there no GPS record from the 13th or daily activity report from the 13th? It's not in there. And that's why when Morales said she was swayed that the OPR file showed Gaines visited a boathouse, where does the boathouse allegation come from? It's not shown in the GPS records. It's not shown in the daily activity reports. Ruffin suggested it. She suggested in her interview with Zabadny. She says, and I'm summarizing here, she says she basically believes Gaines visited a boathouse while on duty. The only thing in the OPR file about that is Ruffin's statement. So in other words, Zabadny doesn't collect any evidence on it. He doesn't show in the GPS records where that is shown. And there's nothing else in there except Ruffin's say-so. And that's the cat's paw. Because Morales said in her deposition, this is docket 136 of page 17, Morales says she was influenced by that boathouse allegation.
All right,
Which
let's say you're right. What's the evidence that your client was supposed to be at those locations during work hours?
The evidence that my client was supposed to be at those locations.
Yeah, he wasn't at work.
He wasn't.
You're. I mean, I think how should I say this? I'm not sure that your characterization of the record on the cross-reference of the GPS, the location of the boathouse, and what I don't know how to say his name is. It's Zabadny. What Zabadny did during the investigation. I think your characterization of what happened is disputed. But is there no dispute that your client was? There's evidence that your client was somewhere he was not supposed to be during the workday?
No.
Okay,
there is
how
no evidence
so?
of that. There's no evidence of that. And Zabadny admits...
Didn't Zabadny testify to that during his deposition?
No.
There are issues in his deposition where he couldn't remember certain details. I know that. But doesn't Zabadny at least establish that there was evidence that he reviewed that established your client was places where he should not have been during the workday, which, by the way, is relevant to the medical excuse?
Your Honor, there actually is not that evidence in the record. Zabadny was asked specifically, where in these GPS records does it show where Gaines is a spot he should not be? And Zabadny said he couldn't identify it.
Well, I thought he said he couldn't remember.
No, he said it was stronger than that. He said he could not identify it. We went over that issue several times with him. I even excerpted in the brief, there's an excerpt from the deposition. This is just one excerpt on page 74. The question was, did you ever discover if this address was connected to Ronald Gaines in any way? In that instance, he said, I don't recall. But then we asked him similar questions about the other two addresses at pages 78 and 79 in his dep. And he said the same thing. But hold on. Then if you go back and you try to understand comparing the daily activity reports with the GPS records, where do these show on themselves that Gaines was a spot he shouldn't have been? They don't. And I walk through this in the brief. And furthermore, Your Honors, let's look at, this is page 216 of the OPR file, is this Google, or this GPS record printout. It shows absolutely nothing. On its face, it's just a bunch of dots on roadways. This shows nothing about Gaines being somewhere where he shouldn't have been. And that's why we say, ultimately, excuse me, breaking down every piece of evidence that is in this OPR file, it is a make-wage sham, and Morales was ultimately influenced by Ruffin filing that OPR complaint register, Ruffin suggesting the boathouse allegation, and doing nothing else beyond reviewing what was in that OPR file. And that's why there's enough evidence here, Your Honors, for the cat's paw issue to have gone to a jury, just like in Schandelmeyer-Bartels, just like in Vega versus Chicago Park District. Now, admittedly, we can all argue amongst ourselves, well, was Zabadny's investigation, does it create too much separation between Ruffin and Morales, or, is Ruffin too remote from Morales? But remember, this should be a jury issue. And plaintiff was entitled to positive inferences about that chain at the summary judgment stage. And we submit, and I come back to this again, and I have to emphasize it. When Morales said that the OPR file showed he visited the boathouse, and the only place in the file where that allegation comes up is Ruffin's interview, that goes to Schandelmeyer Bartel's statement that if you can show that the decision maker was fed false information by the biased person, that's enough for a cat's paw case to get to a jury. And that's what we're arguing about this cat's paw issue. Lastly, I know we've been going on the cat's paw issue for a minute here. I want to emphasize about the other part in the case, which is there enough circumstantial evidence that Ruffin was motivated by age-based animus? And there's 5 circumstantial factors discussed in the brief. I won't hit all of them, but I just want to submit, Your Honors, we submitted 6 affidavits from other employees in the work unit, all attesting specifically, not conclusorily, to different facts why, in their view, Ruffin was motivated by age-based animus. Rare is the employment discrimination case where there's 6 affidavits from other people in the work unit attesting to age discrimination. And we submit that that alone, along with the other 4 circumstantial pieces of evidence, should have been enough for the court to deny summary judgment on that causation issue as well. Excuse me, I see I'm going into my rebuttal time. Are there any other issues at this time? Okay, I'd like to reserve the remainder of my time. Thank you.
That's fine. Ms. Guest.
Good morning. May it please the court, Assistant State's Attorney Rebecca Guest, on behalf of Thomas Dart, Sheriff of Cook County, Carmen Ruffin in Cook County. This is a clear-cut case. The appellant, Ronald Gaines, was terminated from the Cook County Sheriff's Office for violating the sheriff's rules and regulations when he handled personal business in his uniform in a sheriff's office vehicle while on duty, failed to supervise his staff, and on at least 5 occasions visited his personal boathouse and 3 other boathouses during working hours. He was not terminated due to his age. There are 3 reasons why this court should affirm the district court's grant of summary judgment. 1, Ruffin did not possess age-based animus or cause Gaines's termination. 2, Gaines's job performance did not meet the sheriff's legitimate expectations. And 3, Gaines failed to identify a similarly situated individual who was treated more favorably. I want to start with speaking about Gaines's job performance briefly, which is where we spent a lot of the opening. The evidence shows that Adriana Morales, who conducted an independent command channel review after the Office of Professional Review did a complete investigation, which included multiple interviews and looked at a number of documents, medical records, emails, and looked at GPS records. And the record is clear that investigator Zabadna compared GPS records with Google Maps, and they showed that he was not in locations where his electronic monitoring participants were located or where his staff was located. That is not where he was. He was at other locations, his house, his boathouse, other boathouses during working hours. It was plaintiff's burden to provide additional information in this case, and the record is clear. There is no other information. And in fact, plaintiff was not even interviewed because he decided not to show up for his interview. And investigator Zabadna contacted him a number more times, and he did not appear. So Gaines's age discrimination in the Employment Act and Illinois Human Rights Act age discrimination claims fail under both Ortiz and McDonnell Douglas because plaintiff has not come forward with any evidence of age discrimination. As plaintiff was explaining, he is relying on the cat's paw theory in this case, but there is no evidence that Ruffin proximately caused his termination. To show age-based discrimination under the cat's paw theory, plaintiff must present evidence that the biased subordinate harbored discriminatory animus against him and that the subordinate scheme proximately caused the adverse employment action. There is no evidence that Ruffin had discriminatory animus. Gaines points to 4 remarks that Ruffin allegedly made, but these comments are irrelevant because Ruffin was not the decision maker, Morales was, and Ruffin's alleged comments did not have anything to do with Morales' decision to terminate plaintiff. Gaines also attempts to rely on Ruffin's alleged mistreatment of older officers and treating younger officers more favorably, but that also misses the point because Morales determined that Gaines should be discharged, not Ruffin. Ruffin's supposed age bias cannot be imputed to Morales without any evidence that Ruffin acted as a cat's paw.
Can I ask you about the district court's opinion
Yes.
where it cites the standard for comparators, which is something we haven't talked a whole lot about this morning.
Sure.
The district court sure does seem to cite the standard incorrectly. It says that Gaines can't use anybody over 40, which isn't quite right. So why doesn't that compel a remand?
So there are 2 ways that Mr. Gaines was attempting to use similarly situated information in his case. It was under both Ortiz and under McDonnell Douglas. So under McDonnell Douglas, he would need a similarly situated comparator under 40 who was treated more favorably. So in this situation, it would be...
I'm talking about the O'Connor point that Mr. Gaines is raising in the briefs.
Sure. The O'Connor case does not say... That's not what the O'Connor case really says. It says it held that McDonnell Douglas does not require a plaintiff to prove he was replaced by someone outside of the protected class when you're looking under the McDonnell Douglas prima facie case, and that so it does not overturn McDonnell Douglas is basically what plaintiff is arguing here. And that's why that case does not help the plaintiff. And similarly situated information is also part of the evidence under Ortiz, but there is no evidence here because there is no evidence in the record that any individuals under 40 who were AWOL, who were at locations where they were not supposed to be during working hours, were not fired. And in fact, all of the proposed comparators plaintiff has provided are over 40. None are younger. He did not come forward with one person younger because they do not exist. So similarly, plaintiff does not meet the analysis under McDonnell Douglas. Plaintiff was not meeting the sheriff's legitimate expectations. He was violating the sheriff's office policies and procedures when he took advantage of his trusted supervisory position by using time he was paid by the sheriff's office to conduct personal business, and when he was at the various locations instead of doing his job. And the Cook County Sheriff's Office reached these conclusions after following its normal investigative process, which included interviewing 5 witnesses, attempting to interview plaintiff who did not appear, and reviewing the GPS and proxy records along with multiple other documents. And Gaines, again, he failed to identify any comparators. Plaintiff's Section 1983 equal protection claim fails for the same reasons. Considering the record as a whole, no rational jury could conclude that Gaines was terminated due to his age. And because Gaines's claims fail on the merits, there can be no liability attached to Cook County. And unless there are any more questions, I ask that the court affirm the district court's grant of summary judgment.
Thank you.
Thank you.
Mr. Casper.
I talked myself out of breath on direct, so I just want to make two short points. Number one, with respect to the O'Connor decision, I agree with Your Honor's interpretation of it, that it says plaintiff doesn't have to propose someone under 40 as part of the prima facie case. Moreover, though, plaintiff was not using the 6 affidavits as comparators. He was using them as one of the 6 pieces of evidence in the circumstantial evidence pile to show age-based animus. And that use of those 6 other employees as circumstantial evidence was overlooked by the district court's decision below. Last point. During the argument, counsel mentioned that there's evidence that Gaines was at his boathouse. Due respect to counsel, that is not in this record. There's not one iota of evidence in this record that Gaines ever visited a boathouse except for Ruffin's say-so that started that allegation and caused Morales to say she was influenced by it, let's fire her. For these reasons, we'd ask respectfully that this court reverse summary judgment, grant in the district court, and remand for a trial. If there's no further questions, I'll stop.
Thank you.
Thank you.
Our thanks to all counsel. The case is taken under advisement. And our next case for argument this morning, Singh versus Bondi. Yes, Ms. Anderson-Stepanek.
If it pleases the court, Maureen Anderson-Stepanek on behalf of the petitioner Tarlashwan Singh. This case has a long procedural history. This is not the first time or the only petition for review that my client has filed with this court under these facts. But I'm not sure if the procedural history is the matter to which this court would be interested in. It really isn't about how many motions have been filed or how many petitions for review have been filed. It really relies solely and specifically on when does a respondent to immigration proceedings fulfill the requirements of a matter of Lozada complaint for ineffective assistance of counsel. This court has maintained throughout the years that it requires strict compliance. Just so you know, nobody likes matter of Lozada. Attorneys don't like it. The board doesn't like it. Respondents, they don't necessarily know about it. Why is it? And at the moment, there is talk of new regulations related to matter of Lozada. Because it requires this idea of filing a complaint every single time an immigration attorney might fail in some way. We're not necessarily talking about strategic failures, but it could be strategic failures. It also includes a missed deadline. If an attorney makes a human error and misses a deadline, they can find themselves with a complaint for in front of the board of or bar association where they are licensed. In this case, my client may have, well, he did receive ineffective assistance of counsel in that he had an appeal in front of the Board of Immigration Appeals that was denied. And then he had, 90 days to file a petition for review in front of this court. He found a new attorney because his present attorney couldn't do the petition for review. That attorney happened to be in New York. Immigration's federal. You can have an attorney wherever. This attorney failed to tell Mr. Singh that he was not licensed in front of this court. So he had a plan. His plan was to ghostwrite Mr. Singh's petition for review and file it that way. And there is plenty of evidence on the record that demonstrates that this occurred, that there are text message and email exchanges regarding this.
What were the terms of the agreement between Mr. Singh, and the attorney, and why did Mr. Singh not set those forth in an affidavit?
So, he did set what he knew forth in the affidavit. The point is there was no contract. The only thing that this attorney did was issue an invoice that says petition for review, $5,000. As I recall, it's $5,000. Which kind of, I've heard I use this term wrong, but begs the question that can an attorney just avoid putting the terms in a contract and then avoid an ineffective assistance of counsel under Lozada because there is no contractual agreement? Mr. Singh submitted everything that he could with this. Now, the government's going to argue that he never provided evidence that he filed it with the board. Or with the Bar Grievance Association. I would say that that's not correct, that he did provide evidence of that. And as of June 2024, the New York Grievance Committee finally issued a letter regarding this where they said that they thought that this was a better matter to be dealt with under a Lozada claim with the Board of Immigration Appeals. That letter was then served on the board as well as opposing counsel to indicate and confirm that yes, this was received by all the parties, this complaint, and 5 years later, the New York board decided to respond and say, hey, go to the BIA. They're the ones that are going to handle this for you. The fact that the attorney violated numerous rules of ethics and, I would point out, committed a fraud on this very court by pretending he wasn't filing anything with this court, by putting out documents for Mr. Singh to sign as though he was filing pro se. Not just one, not just the petition for review. He then, even knowing this is a jurisdictional matter, filed a motion to ask this court to overlook the late filing of the petition for review and consider it anyway, even though we all know this court doesn't even have the authority to do that. And yes, he failed to respond in any way to any complaints by either the grievance board, by Mr. Singh, by the Board of Immigration Appeals. Because why would you? If part of the requirements of Lozada is to prove certain things, that the attorney has received information, has given an opportunity to respond, which he was, because the complaint was filed with him and the board, and then the motion to reopen wasn't filed until approximately 3 weeks later. There was appropriate time. And there is a factor of due diligence. One of the reasons why Lozada is consistently held to have to be strictly complied with is that there's a public interest here. We don't want people coming back 10 years later saying, oh, I had ineffective assistance of counsel and that's why I was ordered removed. That didn't happen here. Mr. Singh sought out another attorney after his attorney failed within weeks. He did his due diligence throughout this process. He found an attorney initially timely to file his petition for review, and when that attorney failed, he found a new attorney timely to pursue this complaint. Had the board reissued the decision allowing him to timely file his petition for review, we wouldn't be here today. This case would be done. You would have heard the arguments on his asylum claim, and you would have either granted his case or sustained the board's decision. We wouldn't be here 5 years later. But unfortunately, we are. And as I said, by indicating that he failed to comply, in the end, what we are rewarding is bad conduct. I see I'm into my time. Thank you.
Thank you. Ms. Lee.
Good morning, Your Honors. May it please the Court. Sana Lee, representing the Attorney General of the United States. Your Honors, the Petitioner's Counsel has conceded that there is strict compliance required in this court, which they kind of made the opposite argument in their opening brief. But this court does require strict compliance with the matter of Lozada procedural requirements to bring an ineffective assistance of counsel claim. And in this case, the record shows that the petitioner did not meet any of the three required requirements. So first, the board did not abuse its discretion. Its decision was very rational in this case and based on the facts of the record. That the first requirement was that the petitioner's affidavit needs to describe in detail what the agreement was with his former attorney and what that former attorney agreed to do for him. And the affidavit in this record does not include that evidence, that detail. So it's very unclear if there was an agreement between the petitioner and his former counsel. And also, the petitioner argues that the receipt that he provided to the board is proof of this affidavit requirement. And the receipt does not give any of those details either. So the first requirement has not been met. And in Marinov, one of this court's decisions, the court upheld the board's denial of a motion to reopen in a similar situation just based on the failure to file, to meet one of the requirements. In that case, the board determined that the petitioner met two requirements but didn't meet one. And so just based on the failure to meet one requirement, the board can deny a motion to reopen in circumstances like this. Going to the second requirement, Mr. Singh did not provide proof that he informed his former attorney about these allegations. So there's no proof in this record that the former attorney knows that he's made these allegations or that he filed a motion to reopen alleging ineffective assistance of counsel. And the board also requires an opportunity for that former attorney to respond to these allegations. So there's no proof of any of that in the record. Okay, and then going on to the third requirement, the petitioner had to show that he filed a complaint. Well, only if he argues that the former attorney violated ethical or legal obligations. So there's not a requirement that they file a complaint, but if the petitioner thinks that he violated certain rules, then he should file a complaint with the disciplinary authorities. And so he alleges that he did file a complaint with a New York grievance committee, but there's no proof that he actually filed this complaint. So the record has a form, a copy of a form that alleges that the former attorney was deficient, and but there's no proof that this form was actually filed. And so there's no showing that the grievance committee received that complaint in a proper manner. And the record doesn't show that he met any of these three requirements. And so the court can uphold it.
What's Lozada's history before the Supreme Court, if any?
Lozada's history? I don't think that case
The Supreme Court has never approved Lozada, and the due process holding of Lozada. That's an administrative decision of the BIA,
Right, Your Honor.
and the whole Lozada right, quote unquote, and due process right, and the procedural requirements to assert a Lozada ineffective assistance of counsel claim are all administrative inventions that have
To
never
my
been
knowledge,
approved
yes.
by the Supreme
Yes, Your
Court.
Honor. Yes. That's correct.
Which is why we just strictly adhere to them as an administrative matter,
right.
without questioning the underpinnings of either the procedural requirements or the underlying legal analysis of the due process question, which was dealt with in Lozada in a matter of one paragraph.
Mm-hmm.
So the whole pedigree of this claim, although we've been living with it for 40 years, not me, but the courts have been living with it for a very long time, as has the agency.
Right. So yes, I don't believe that the Supreme Court has upheld these.
To your opposing counsel's point that nobody likes Lozada. I'm
Well,
trying to isolate the
I-
meaning of that claim.
I'm not sure
and
what.
I-
I'm not
it
sure
was
what she
asserted
means
that
by
everybody hates it, or everybody dislikes it on both sides.
Okay, that I was confused by. I'm not sure why she says that the board dislikes its own decision, and this court has upheld these procedural requirements in many, many, many precedential decisions.
Understood.
Yes.
Is anything changing about the deference we owe to this administrative standard?
Well, as far as Loper Bright, petitioner hasn't raised that issue, but
Loper Bright's a statutory case.
Right.
Lozada is a constitutional, administrative, constitutional/administrative
right.
I'm
holding.
not.
So
Okay.
I didn't mean to suggest. I'm not asking about Loper Bright. You introduced Loper Bright.
Okay.
I'm picking up on Chief Judge's question about we've been living with it. We've been respecting the standard from your position at the department. You know, has anything changed about the difference we ought to give to this case that has not been challenged, as my colleague has stated? Has not been
No, Your Honor.
evaluated
I don't
by the
think-
Supreme Court.
I don't think that the level of deference should change. I think the court has deferred to the board's discretion and to these rules.
I guess, and I think we're both struggling to kind of get to the bottom of a shifting argument, and maybe we should address these questions to Ms. Anderson-Stepanek when she gets up to the podium again. But we were asked to, at least obliquely asked to, rethink our strict adherence to Lozada because other circuits don't require it, notably the Ninth, maybe others I don't remember. And that's the question of deference. We do so because this is an administrative resolution of the due process implications of ineffective assistance of counsel in before the immigration agency, and petitions for review to the federal appellate courts. So we take Lozada as it comes to us and require compliance with it. Other circuits apparently are looser about that. They don't require strict compliance. And there was a suggestion that we should maybe relax our strict compliance standard. That's different from what's being argued from the podium. So, but to the extent that we were, at least in the briefing, invited to rethink our strict compliance, what's the government's position on that?
I don't agree with that, Your Honor, because the court and the board in its decisions have provided reasonable rationale for these procedures. And so the failure to meet any one of these procedures, I think, is a good reason to deny a motion to reopen, because the board receives so many of these motions to reopen, and it needs a basis to analyze the substance of the claim. And so no, we don't think that the court needs to revisit it. And even if it did, the petitioner didn't meet any of the 3 requirements. So not even one. So I think that's a moot issue in this particular case.
Thank you.
Thank you, Your Honors.
Ms. Anderson-Stepanek. You know what's coming, so perhaps you can clarify your statement that everybody hates Lozada, and whether you're asking us to reconsider our strict compliance with its procedural requirements, or you're working within our case law.
Well, I think it's a little of both, to be perfectly honest. And I think my statement of everyone hates Lozada might have been her, hyperbole to a certain extent. But I think we only have to look at the board's own decisions when it comes to when they are determining cases under the Lozada standard. It's very obvious that they don't like it. Presently, the Attorney General has legislative language where they are looking to undo Lozada or come up with a new scheme or something like that. There's nothing new to be in a few years, maybe longer than a few years ago, 7 to 10 years ago, got rid of Lozada temporarily, and then it reared its ugly head again. So this isn't anything new. And as far as one last thing, because I know my time is almost up, what is strict compliance with Lozada? Counsel, who, by the way, I did CC the grievance letter to her, and the board has it, and they had the opportunity, once they received this, to say, well, they've proven this. We see the egregious conduct by the attorney. We have sua sponte options to reopen this case. They chose not to, okay? So the point that I'm trying to make here is that how much does a respondent have to do, especially when the person with the power that had the knowledge, that is supposed to draft the agreement, that is supposed to tell the individual, this is what I'm going to do for you on your behalf. And then the courts say, well, no, you wrote a affidavit. You said what you understood he was going to do on your behalf. You provided an invoice. I assume that's what she meant by receipt. You provided the invoice that said, petition for review. You provided an affidavit from your American mother, who's a judge, Bonaventura, that said the same thing, that corroborated your statements. And yet, because there's some magic words that I am unaware of that weren't in the affidavit, it supposedly fails. What is strict compliance with Lozada? It's a little unclear. So, thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement. And our 5th case for argument this morning is United States against Docks at the Door. Mr. Ackerman.
Court, please. My name is Alan Ackerman. I represent Dr. Fayani and Docks at the Door. For our purposes, I think Fayani is sufficient, so I'll leave out Docks at the Door. With the court's permission. Good morning.
Good morning.
If it please the court, counsel for the government, the genesis of this case as we see it is a relevant conduct restitution order in the sum of $523,000 based on a misdemeanor guilty plea under 18 U.S.C. 669, paren A close. Now, the problem with that is, and I sent a Rule 28J note to the court, I hope it been received, I hope so, that restitution cannot be based on relevant conduct unless it's part of the count of conviction. Here, there's a single misdemeanor count of conviction where the defendant...
Did you make that argument in your brief, Mr. Ackerman?
I did not.
Isn't that a problem for you?
It's a waiver question or it's a 2106 fairness question. I'm not sure. If the court elects to overlook it this way, fine. But the reality is it's an improper restitution order to begin with. As the genesis for this case, the government took that order and got a summary judgment.
Does that, well, let me ask you, does that make any difference in this case? Because your client didn't respond to the 56.1 statement, so he admitted the facts, which were the genesis of the order, and you still got the plea agreement, which is problematic. So does it make any difference? The plea agreement is not
problematic. It's the restitution order that's impermissible under the law of this circuit. So if you use that as a starting point, which the government did, and you get the summary judgment, which it did, although there was opposition to the summary judgment before the district court. Now that there was. And look, the fact that defense counsel in the criminal case, the 533 case, did not challenge the relevant conduct, he may not have known about it. There's two cases. One of them is a 2025 case, which I cite in my 28J, and the other goes back to 2006 when Judge Posner wrote that in the criminal opinion that we're talking about. So that's the law of the circuit. Now they take the law of the circuit and they go against that, but the government is smart. These my opponents here are very, very fine lawyers and bright people. And they didn't just come into this case at the summary judgment part. They were there for part of the criminal case. The criminal case I wasn't part of, but it lasted 3 days. There was some sort of mistrial motion, I don't recall exactly what, something about a tape or something that wasn't disclosed, although the government can certainly tell the court about that better than I can.
It doesn't matter.
Okay. But that's the genesis of how this plea agreement came about. So instead of retrying the case, the 12 felony counts, they offer him a single count misdemeanor, $85.87 or $87.85.
Did Mr. Ackerman ever object? Well, it would be a negotiation issue.
I'm sorry, Chief Judge Sykes, I couldn't hear you.
It's actually coming from
I'm speaking. It's Judge Jackson Acumi speaking. Did Mr. Ackerman ever object? It's more of a negotiation issue to the factual basis in the plea agreement, because that's really what's at issue here, is the factual basis in the plea agreement, not the relevant conduct findings.
It was all done in one day. On August 22nd, I believe is the date, there is a plea agreement, a conclusion of the jury trial. The jury is dismissed, and there's the guilty plea. And as part of the opening appellant's brief, which I did not write, but I'm arguing on behalf of it, the defendant was quizzical about the amount of money involved because the district court kept asking him about this money. He had to accept it. Had to. Otherwise, there was no plea agreement.
Did Mr. Ayani, because did he lie under oath when he said the statements in the factual basis were true and correct?
He agreed. He signed the plea agreement. That he agreed.
But I'm also talking about the plea colloquy.
No, the plea colloquy, he talked about the $87.85. That's what he talked about. The government was interested in the relevant conduct part of it because the misdemeanor could only yield a single year in prison at best, and forget about what the defendant knew or the defense counsel knew. The government knew or should have known that the restitution order, which is the heart of the summary judgment, because that's what they rely on to get the summary judgment in this case. They knew or should have known that you could not have a $523,600 restitution order on relevant conduct in the misdemeanor case because there's nothing else in the single count information. That's all. So I'm trying to reduce it to reality here. You have a $25 million judgment out of a relevant conduct order that shouldn't have been entered in the first place because it was impermissible under Seventh Circuit law. Those are the bare facts. So if those bare facts equal, you know what? Maybe something's a little skewed with this summary judgment here for $25 million. Maybe something's wrong. There was never a district court hearing here, by the way.
I'm a little confused about your reference to a relevant conduct order. There was a restitution order as a part of the sentence here, and that's where the $500,000 figure came in that your client admitted to in his plea agreement, and as well as the number of false claims. But the dollar amount was in the restitution award, the restitution order, not a relevant.
It's not a fine. It's restitution in the judgment order in the criminal case.
Right, but you keep referring to relevant conduct order. I think you mean restitution
Because it
order.
didn't come out in the charged offense, the single misdemeanor. It was part of the plea agreement.
I understand there was a misdemeanor compromise to resolve, in the middle of trial, to resolve the 12 felony counts. I think I'm tracking on that.
I don't know that there's a compromise because even in fairness to the lawyer in the criminal case, he did file something before sentencing. I don't know what he called it, sentencing memorandum or something, where he suggested that the restitution should be $200,000 less than it was. He never raised the issue that it's impermissible to begin with. Now, I'm assuming he didn't know. That's my assumption.
All right.
Yeah, and Your Honor brings up a very fair, very fair. Could it have been part of a bargaining process? The record doesn't disclose that. That's my point.
Or more simply, we wouldn't be here if Ayani and his counsel and the government had not put these details in the plea agreement, but they're in the plea agreement. Right? Would Ayani, in other words, have been better off had these extra details beyond the misdemeanor charge of conviction not been in the plea agreement, the factual basis?
My age is catching up with me. I'm having trouble hearing you, Justin. But may I?
I'll shorten it. The real problem is that these details beyond the count of conviction are in the factual basis of the plea agreement. Is that correct?
No. I'm assuming the factual basis for the plea is that he overcharged by $87.85 or that figure for the single misdemeanor count. Remember, this is the conclusion of a 3-day jury trial where there was the threat of a mistrial or something. But again, government counsel was there, so she can tell you all that, and my time's up.
Thank you.
But thank you for listening.
Thank you very much. Ms. North.
May it please the court, counsel. All of the arguments you just heard today are waived. They're new arguments, this whole relevant conduct, red herring, the attacking the criminal case. None of this has been litigated in the civil case, was addressed below, and all of it should be set aside as a tangent. The true essential important thing here for the court is that these facts are all undisputed. As Judge Kirsch pointed out, these facts were set out in the Rule 56.1 statement at summary judgment. They were not disputed. How could they possibly have been disputed? They were sworn to in a plea, as Your Honor rightly pointed out, and they're not saying, oh, I lied in my plea, so of course they can't dispute them. They didn't dispute them. And so the district judge here, Judge Pallmeyer, was on very solid ground, not only on the estoppel law, the False Claims Act estoppel provision that provides for the judgment here, common law collateral estoppel, but also based simply on the fact that the government put forward a series of facts, cited a basis for them. Those facts were not refuted, and those facts amounted to violations of the False Claims Act to the degree here, which is 4,367 false claims that Mr. Ianni caused over about 4.5 years.
Well, to be very precise, and I don't mean to split hairs, but the statement of facts that the government submitted in this False Claims Act case did not affirmatively put those admissions from the plea agreement in the summary judgment record for purposes of inviting a denial or a non-denial from Mr. Ianni and docs at the door. The statement of facts said that in his plea, Ianni stated that during the time in question, Medicare paid this $500,000 figure and these 4,000 plus, and docs at the door submitted these 4,000 plus false claims. So basically the recitation was the facts of the plea, not the underlying facts. Well, and so when there was a non-denial of that, all we have is the plea agreement in front of us. So the question remains, what form of estoppel is appropriate to apply to that plea agreement and the judgment that produced it, which includes the restitution order that reflects that $500,000 and that 4,000 plus false claims. So we still have an estoppel question.
I hear you, Your Honor. I do think, however, the court doesn't actually need to reach estoppel because of the fact that those facts were set out and they weren't responded to, just based on the court's precedent. But moving
they were set forth in terms of what was in the plea agreement.
Right.
And so we can accept that those facts were in the plea agreement.
Right.
He didn't admit in this proceeding to those facts by failing to respond to them. By failing to respond to them, he admitted that the plea agreement says what it says, is what it is, and whether or not it has estoppel is a legal question for us.
Okay. I do just want to respond that if, for example, this wasn't a plea and it was sworn testimony somewhere else, and you said, you testified A, you testified B, you testified C, and the person never came back and responded, that's all evidence that is that person's position, that is what happened, right? So you taking that evidence and having that evidence not responded to, the government said below, these are judicial admissions, you also didn't respond to any of these facts. All of these facts satisfy a False Claims Act judgment for 4,367 false claims, and below, Mr. Ianni did not respond to those arguments, even in the brief. The judicial admission argument, the fact that all of these facts satisfy False Claims Act. So I just want to respond to that sort of contention. And then moving over to what you were specifically asking about collateral estoppel, of course, there's two bases here. And the district judge was on firm ground finding estoppel under False Claims Act provision. There are several cases that we have set out in our briefing where, as often happens, the factual basis of the plea describes the scheme, describes something broad, is not actually relevant conduct in the way we think of it. You know, this was a plea factual basis, not some sort of related or associated or separate scenario. And in cases like Harris, in cases like Olive in the Eighth Circuit, in the e-biofuse case, all cited very similar scenarios, also under the False Claims Act, holding that Section 3731E applies, that estoppel applies even where the defendant has pled guilty to, as typically happens, one single charge, but has pled guilty to that as part of a scheme and has admitted the details of that scheme. So that's the statutory estoppel.
Is that a sound interpretation of the statute?
I do
the
believe
scope
so,
of
Your
the
Honor.
statutory estoppel principle is limited to the essential elements of the offense.
Correct, Your Honor.
Does that refer to the charged offense? Does that refer to the offense of conviction?
That is not.
And what are the essential
Sure.
elements once we isolate our, our unit of analysis?
Sure. Well, obviously, what counsel, Mr. Ackerman, would like to view it as is solely the one obvious charge there.
Well, that's what the statute says.
Well,
so that's not like
okay.
a totally far-fetched position.
Okay. That isn't how any other court has found it.
Okay, I'm asking you a direct question,
Sure.
so don't just
Sure.
seek
Okay.
refuge in what other courts have
Okay.
said. Tell me straight up why your interpretation is a sound interpretation of the statute.
Because I don't think the statute was ever believed to...
Text first.
Text first. So it's...
Always
it's
text
this-
first.
Okay, well, it's the same transaction, all right? So the same transaction being the
The
same...
statute
fraudulent
refers
scheme.
to, that's a common law estoppel question. You're on really firm ground on common law estoppel,
Right.
first of all. I'm trying to focus on the the scope of the statutory estoppel principle, and maybe we should just completely avoid it in this case because it's not necessary to an affirmance here, because you're on such solid ground on the common law estoppel. But there is a statutory interpretation question here
Okay.
about what the scope of the statutory estoppel principle is.
And-
the text
and-
says
right.
essential elements.
So you're focused on that, the essential elements. Of
That's
the
what the
offense.
statute
Right.
says.
Okay.
I'm
I
not
was just
raising a
when you were-
far-fetched question.
Sure, there are just a bunch of other pieces of it, and that's why I was sort of addressing some of it, but I will focus in on this one. So the essential elements of the offense, as we view them, encompass the fraudulent scheme and are not an offense in the parsed out notion here. And because the False Claims Act is used routinely to address business schemes.
What statute was he convicted under?
Pardon me?
What statute was Mr. Ianni convicted under?
It was a embezzlement of Medicare funds.
And what are the elements of that crime?
The elements of that, well, it is in general a fraud and false claim statement, but I don't have the...
Isn't that what we should be focusing on in terms of the statutory component of this estoppel claim?
Your Honor, the specific charge of this offense, the particular things that were done for him to plead guilty are the same scheme. But I agree with you. You do not actually have to reach that. There are 3 different ways for us to get to it. I totally appreciate you are unconvinced by that, but collateral estoppel, common law, applies here as well. So thank you. If there are no further questions, we ask the court to affirm.
Thank you. Mr. Ackerman, your time had expired, so we'll take the case under advisement and move to our last case today with thanks to all counsel. And our last case this morning is United States versus Rogers. Ms. Lennon?
May it please the court. Patrick Rogers is not suggesting that the district court imposed a substantively unreasonable sentence, and he's not arguing that the district court was prohibited from structuring the sentence in the way that it did. Our overarching complaint here is that the record lacks a meaningful explanation for the imposition of a 120-month sentence on count 1, the drug count, and a consecutive 18-month sentence on the felon in possession count.
Let me ask you a question on that.
Sure.
There is an explanation. It's on page 29 of the sentencing transcript. And there the judge said, in balancing those factors in the court's view today requires a sentence of 120 months as to the offense of conviction in count 1 to be followed by a consecutive sentence of 18 months as to the offense of conviction in count 3 for a total sentence of 138 months. If the judge had said the following, and in balancing those factors in the court's view today requires a sentence of 138 months to be designated as follows: 120 months on count 1 to be followed by a sentence of 18 months on count 3. Would you be here today?
Yes.
How so? Because this happens all the time, where the judge takes the guidelines and determines the appropriate sentence under the guidelines is 140 months. How do I get there? The felon in possession count 1 conviction carries a statutory maximum of, 120 months, or the defendant pled guilty to 4 phone counts. The appropriate sentence is 120 months. To be served 48 months on count 1, 48 months on count 2, 48 months on count 3, or whatever you get to get to the total sentence. What's wrong with that?
So my response has a couple of parts. First, I think we would still be here, to Your Honor's first question, because the sentencing judge did not explain what factors and how the court was weighing those factors.
Well, the 3053A factors.
Right, Your Honor. That's what the court was referring to, but the court didn't explain how Mr. Rogers' personal history and characteristics influenced the sentence. The court didn't explain how necessarily the offense conduct was weighed in the determination.
Well, I think he did. I mean, he talked about fentanyl, and a lot of the stuff is very favorable to your client that the court was talking about, which you can only conclude resulted in the below guideline sentence, I think.
And I think that the end of Your Honor's statement right there, the I think part, is the problem here, because we don't know whether it was the offense conduct.
Well, he didn't go above.
Correct. He did not go above. But we also don't know whether a 120-month sentence, which was the sentence the court imposed on count 1, why didn't that account for the offense conduct?
What judge would do that? I mean, I guess, are you setting up a standard where a judge has to explain why the judge didn't give particulars? I didn't give 110 months for this reason. I didn't give 120 months. I didn't give 115 months. I arrived at 138 months. I mean, I don't. What standard are you setting for district judges here?
So here, where the statute 3584 starts with the default of concurrent sentences, where the guidelines also start with the default of concurrent sentences, where the defense was asking for a total sentence of 120 months and set forth arguments in support of that sentence, and where the court ultimately decided, as I stated earlier, that a sentence of 120 months was appropriate on the drug count, which necessarily involved the conduct at issue with the gun count too, at least in how the guidelines were calculated and grouped.
Where did the judge say that 120 months was adequate on the drug count?
That is the sentence that the court imposed on.
Because
on
that's
that
the
count.
statutory maximum.
On the drug,
on count 1, the statutory maximum was 120 months, right?
On count 1, the statutory maximum was life.
I'm
the
sorry,
statutory
minimum 120 months. Yeah,
Yes.
minimum 120 months, right.
The maximum was 10 on
Right,
count
you're
3,
right,
the
you're
felon in
right.
possession, yes. But the court did say that 120 months was appropriate on the drug count, and the conduct there would necessarily have incorporated the gun also in how the guidelines were calculated, at least. So there are all these factors that weigh in favor of a concurrent sentence here, but we don't have any explanation for why the court disregarded all of those different factors and instead imposed a consecutive sentence. And more generally, we don't have an explanation for how the court weighed the 3553A factors and how the court considered or didn't consider or didn't agree with the defense's arguments.
Well, no, the judge explained at length his analysis of the case under the 3553A sentencing factors, discretionary, the factors that guide his discretion. That's all over this transcript. The fact that he didn't link it to the decision to structure the sentence in the way that he did, 120, the mandatory minimum on the drug count, followed by 18 months on the gun count for a total of 138, doesn't make any difference here. There's no requirement that he provide some sort of fact-based rationale for doing that. He decided, based on his holistic evaluation of the case and the defendant's history and all of the other 3553A factors, that 138 months was the right sentence, and he structured it in the way that he did, 120 followed by 18. Those are both within the statute, and nothing more is required.
I don't believe that we have a holistic determination here. I don't believe that we have an individualized sentence. In the factors considered by the court, 3 pages of the district court's explanation for the sentence, by the court's own admission, apply to 40% of the cases before him. The fentanyl, the issues with fentanyl and the community, the dangers of fentanyl, the epidemic, that's not individualized to Mr. Rogers. That's a problem, and that certainly could be considered, and I'm not saying that the court can't consider that, but that's not an individualized sentence. That's not considering Mr. Rogers and his impact on the...
You're requiring the impossible here. The judge is perfectly free to comment, especially in drug cases, about the community impact of the drug trade, and in particular fentanyl, without creating an appellate issue. There's nothing wrong with that, and that doesn't take away from the rest of the analysis here, and it certainly doesn't call into question the 138-month sentence or how the judge structured it between the 2 counts as a consecutive sentence.
I agree with Your Honor that the court is not prohibited from considering that. I agree with Your Honor that it's appropriate for the court to consider that, but what also needs to be considered are Mr. Rogers' individual circumstances, and I don't think those were here. And I also think that given, as I was going through earlier, given the default in the statute for concurrent sentences, and especially the defense's argument for a total sentence of 120 months, the court just needed to explain why that wasn't appropriate. I could see the court saying something along the lines of...
Nothing in the law requires the judge to explain why he or she is rejecting the defense proposal. That's not required.
But the law does require the judge to explain why a particular sentence is appropriate for a particular person. And I don't think we have that here. And
that's really an overstatement. The judge is not required to state why a particular sentence is appropriate for a particular person. There are many inputs into the sentencing decision, including the effect on the public, including the nature of the crime, the severity of the crime, the victim statements, the myriad factors, as you well know. So
yes.
Your statement just now was vastly overbroad.
I don't think it was overbroad, Your Honor. I think that plenty of this court's case law establishes that sentencing determinations are individualized assessments that need to
that
consider
focus
the
on
person.
the total case, not just the defendant's characteristics. And you made a statement that sounded an awful like a categorical rule that the defendant has to, or the judge has to explain why X number of months is appropriate for this defendant, presumably in personal terms, as opposed to the totality of the case. That's not required. The law doesn't require that. No statute does. The guidelines do not. No gloss on the statute or guidelines requires that.
And if I misspoke or, implied something different than what I intended, I apologize. But what I intended to say is that it's an individualized assessment. All of the factors need to be weighed. It's not okay for the court to only focus on the fentanyl epidemic, though that is a proper consideration, or just focus on, the costs of incarceration, which may be an appropriate consideration too. Those, though, apply to the people in general, and not just Mr. Rogers. And I do believe the case law establishes that all of the 3553A factors do need to be considered, which would include a person's personal history and characteristics. Now, do those have to play the most important role? Certainly not. But they have to at least factor into the court's decision. And I think they especially do here, where the defense was making arguments that were related to Mr. Rogers' personal history and characteristics, and they were non-frivolous arguments, which Rita says need to be considered. That's the threshold. Non-frivolous arguments must be considered by the court. And we have the defense talking about Mr. Rogers' age. Mr. Rogers mentioned that too. We have the defense talking about double counting in this case, which is an offense characteristic, still needs to be considered. We have the defense talking about double counting of Mr. Rogers' criminal history, his one prior conviction. Those things weren't adequately considered by the court, weren't mentioned in the district court's explanation of sentence. We don't know how those factored in, and that is a problem, because non-frivolous arguments do need to be addressed by the court. Now, the court, and I wholeheartedly agree that the court doesn't have to agree with the defense's arguments, but the court has to at least consider them, and that wasn't done here.
Thank you. Mr. Koenig. I'm sorry if that surprised you. Your light's been on for some time.
I apologize. Thank you.
Thank you.
I got wrapped up.
Good morning, and may it please the court, my name is Jonathan Koenig. I appear on behalf of the United States this morning. Some years ago, the retailer TJ Maxx had a jingle that went, "Get the max for the minimum at TJ Maxx." I don't know if you remember that. Kind of came into my head during Ms. Lennon's presentation, because I think there is a kind of pedestrian explanation for why we're here. And that is that the sentencing judge, prior to sentencing Mr. Rogers, had an experience in the Vance Fields case where he kind of got burned by concurrent time. If I can just borrow the numbers from this case, what he did was he said, okay, 138 months on both counts concurrent. And then it turned out, oops, everyone later realized that one of those counts had a statutory maximum of 120 months. And that had to be corrected by way of a joint petition for a remand. It was messy. And that was a recent experience that hovered over this sentencing proceeding. You can see it on pages 15 to 17. If that context is helpful at all.
It's a little helpful. It's just a little odd. I mean, usually you would expect, here, Ms. Lennon is right that the maximum on count one is life. So typically you'd see the judge sentenced to 138 months on count one, and then the judge could sentence to the maximum on count two, 120 months, right, to be served concurrently. It's a little bit odd when a judge, particularly in a case like this, says the statutory minimum on count one to be followed by 18 months on count two, but still we can see how he got there. He decided on a total sentence of 138 months, and then he split up the counts different, which would be weird. I mean, the only reason, I think the only effect that has, I mean, you tell me if I'm wrong, but I think the only effect that has is if, let's say, count 3 was thrown out on appeal, then the defendant would have a 120-month sentence instead of 138 months. Or if count 1 was thrown out on appeal, the defendant would only be serving an 18-month sentence because that's what the defendant was sentenced to on count 3. I think that's why district judges typically do not do it that way.
And I would say our office has an institutional preference for the mechanism that you just laid out, for the reason that you laid out, which is things happen. You know, the law changes, and sometimes counts are overturned, or the law changes. And
let me ask you a different question. We have said, in U.S. v. Nania, N-A-N-I-A is a good example. We've said courts must correctly determine whether the guidelines recommend concurrent sentences. And then in that case, we said failure to do so results in procedural error. So that leads me to my question in this case. Where do we see the district court here correctly determining whether the guidelines recommend concurrent sentences?
Well,
where do we have the recognition or any sense in the transcript that in this particular case, the judge is aware of the default being concurrent 5G 1.1 and has explained his decision, which he's well within his rights to do, we've all discussed that, to structure it otherwise?
there's no direct consideration of that, Your Honor, to be candid. On the other hand, nobody asked for it either, and that's where our plain error argument comes in. This entire argument about the structuring of the sentence.
Is your only response that no one asked for it? Because, and then that leads to the plain error argument, because your plain error argument runs headlong into a lot of our precedent about not having to take exception during sentencing to a judge's sentencing decision. So I want to know if you have a different argument.
Well, respectfully, I disagree that this case is problematic. My argument in this case, my plain error argument, is problematic in light of the you don't need to take exception line of cases. So if I could just address that part for a moment. Our understanding of that legal proposition, which derives from Rule 51, is that when the judge explains the sentence, the defendant doesn't have to stand up and say, I object, or I take exception, Your Honor. That doesn't relieve the defendant of raising arguments when it has an opportunity to do so. And in this case, there was no argument along these lines.
But the judge doesn't say until the end of sentencing that this, the judge doesn't say until the very end of sentencing, we were at the page, that it's going to be consecutive.
Well, the argument came up even earlier, though.
About the state sentence.
Well, yes. So in a general sort of way, this consecutive concurrent issue was kicking around. The prosecutor on page 18 says something along the lines of how you choose to structure this doesn't matter to the government. And then defense attorney has a chance to speak after that and says absolutely nothing about it. So that would have been the time, if the defense cared about the structuring of the sentence, to raise the argument and preserve it under Rule 52. Again, I'm mindful of the cases that you're talking about, and I obviously don't want to run afoul of the very recent statement in Martin, like, wake up, this is serious, like, we understand all that. But I don't think that this is a taking exception scenario, respectfully. And I hope I answered your question.
So your answer then is there is no statement here on this transcript where the judge is correctly determining whether the guidelines recommend concurrent sentences, quoting again from Nania, but your answer is no one asked.
I don't see it in the transcript, not a direct consideration of it, no. The other thing I'd like to discuss is whether or not there was an individualized sentencing in this case, because my opponent emphasized that in her remarks. I disagree with her. I think that, you know, there was some noise in this hearing about BOP policy and the cost of incarceration and whatever, but it's very clear that this judge had reviewed the PSR, was familiar with the dimensions of the fentanyl crisis and the need to protect the public, and also with the defendant's admission about using guns to protect his drug trafficking activities. And he directly addressed Mr. Rogers at the beginning of the hearing. This is on pages, or beginning of his remarks at pages 23 and 24. You should have realized how dangerous these activities were. And so I do think there was an individualized consideration of the case before the court, even though there may also have been other issues that the judge wanted to talk about. Respectfully, I don't think the so-called Cunningham arguments that my opponent says ought to have been addressed were really worthy of comment. One is that a 41-year-old defendant will be approximately 50 when he gets out of prison. Maybe it's just my own age, but I don't see those numbers as being screaming out for the detailed consideration of, you know, do defendants age out of crime and that sort of thing. There was certainly no real substantiation of that argument with data or studies or anything. It was kind of almost an afterthought. And as far as double counting, there was no double counting, at least as a guidelines matter, because the firearms count dropped out of the analysis. So the only guideline enhancement is the one that attached under 2D for use of a firearm. So that was counted once. And again, it's the kind of argument that is so insubstantial that it doesn't really require the judge to spend time on it. And my last comment, I suppose my opponent didn't really talk about her Section 2106 argument, but we think that this case is clearly distinguishable from Claiborne and Easterling, the 20HA case, where the defendant faced, his sentence was 175% higher than the high end of the amended range. There was nothing like this here, and of course, the judge had already adjudicated Amendment 821 in a Section 3582C2 proceeding. So there's several reasons, at least, why these cases are distinguishable, and really no limiting principle articulated by my opponent for when 2106 applies and when it doesn't. Does the panel have any more questions? For the first time in a long time, I'm over my time. But
Thank you. Thank you. Ms. Lennon, anything further? You used all your time, but you can have a moment to sum up if you have anything else to say.
I will try to be very brief, Your Honor. I want to just briefly touch on 2106, 28 U.S.C. 2106, and our argument there, because I do think that that is the cleanest way for this court to resolve this case right now. With a remand for resentencing, it would allow the district court to address not only Amendment 821 and its impact here, which it does have a significant impact, but also address the other issues that we don't think were adequately addressed, and explain the concurrent versus consecutive sentence, address the mitigation arguments and those things. I do think that provides the cleanest, most straightforward way of doing so.
Are there any cases supporting the use of that sort of omnibus provision for a below guidelines sentence that is not being challenged on substantive reasonableness grounds?
I don't believe there is a specific case in the Seventh Circuit that supports the use of 2106 or
400-month sentences, sentences of multiple life terms consecutive, et cetera, where there's perhaps been a misfire or miscarriage of justice by the district court.
To answer your question directly, I haven't found one. I wish I would have been able to find one. But at the same time, I do think that Mr. Rogers' sentence was anchored to the guidelines. I do, the court reduced it by 30 months, which is the amount of time from the bottom of the guidelines, which was 168 months. The court ultimately imposed a 138-month sentence. That's a reduction by 30 months, which is the amount of time that Mr. Rogers' case was pending, the amount of time he was in custody after the offense. So I do think, if that's in fact how the court arrived at the sentence by reducing it by 30 months, then it was tethered to the bottom of the guidelines, and I do think then Easterling's logic and Claiborne's logic would apply here, and the court could remand under 2106 for the district court to consider the impact. Thank you.
Thank you. Thanks to both counsel. The case is taken under advisement. And that concludes our calendar today. The court is in recess.